A very good evening, gentlemen. I am sure we all have quite a lovely and awesome day. All right, so welcome to tonight's online session. I'm still your host, O.O. Stevens. And tonight we're going to be looking at the topic, Company Proceedings and Jurisdiction. We're going to be looking at the topic, Company Proceedings and Jurisdiction in corporate law practice. And first of all, we're going to be looking at the courts with jurisdiction as it involves issues arising from companies in Nigeria. The court with jurisdiction as it involves issues arising from companies in Nigeria. We have the Federal High Court, we have the National Industrial Court, we have the Investment and Securities Tribunal, we have the International Center for Settlement of Investment Disputes, we have the Tax Appeal Tribunal, we have the Federal High Court, I'm taking it again, we have the National Industrial Court, we have the Investment and Securities Tribunal, we have the International Center for Settlement of Investment Dispute, that is ICSID, ICSID, and we have the Tax Appeal Tribunal. And somebody would ask, what is the National Industrial Court doing here? Remember that a company can be an employer of an employee, and matters arising from employer-employee relationship must definitely be treated by the National Industrial Court. Another person will ask, what is Investment and Securities Tribunal doing here? We are going to see the jurisdiction of Investment and Securities Tribunal. Somebody else will ask, what is ICSID doing here? That is the ICSID. That is an international dispute resolution tribunal for investment disputes. And somebody will also ask, what about a tax appeal tribunal? Of course, you know that that companies pay taxes. To some instance, the tax appeal tribunal would have to hear matters relating or matters arising from company. Now, what are the mode of commencing corporate suits at the Federal High Court? What are the modes of commencing corporate suits? That is matters relating to company. What are the modes? There are three modes. You can commence it by way of originating summons, you can commence it by way of originating motions, and you can commence it by way of petition. Please note this. You can never commence any matter relating to company by way of a writ of summon. So note this for your MCQ mainly. Assuming something comes out from there, they could actually give you, they could tell you something like all except one is a mode of commencing a matter in the Federal High Court with respect to companies. You will see writ of summon, you will see petition, you will see originating summon, and you will see originating motion. Just know that writ of summon is the answer. You can never commence matters relating to company at the Federal High Court by way of writ of summon. However, the default mode of commencing actions in the Federal High Court for companies proceeding is originating summon. The default mode, that is the known mode of commencing matters that relate to a company in the Federal High Court is by way of originating motion. And somebody may try to apply or use his knowledge of what he was taught in civil litigation, that originating summons are used, that the petitions are used in companies. Please, it is only with respect to winding up of companies that you use petition and some other specific matters. So it doesn't mean that it is only petition that is used in matters relating to company. So just note that, remember, it was specific in the instance given in that civil litigation about the mode of commencement, that it is only with respect to winding up of companies that you use petition. That doesn't mean that petition is the only mode of commencing company-related matters in the Federal High Court. Let us be guided on that. And the matters which are to be commenced by originating summons are all proceedings involving companies under the company proceeding rules, except those for which there is an express requirement for another mode. There is a rule known as company proceeding rule, that is in CPR. For most of us that have bought our statute book on company law, you may be fortunate to see the company proceeding rules. So we are saying now that all matters that are really contained in the company proceeding rules are expected to be commenced by way of originating summon, except where it is expressly stated in that company proceeding rules that this particular or that a particular matter shall be commenced by a different mode. And now, what type of matters do we commence by way of originating motion in the Federal High Court relating to companies? These are usually used where there is a need to rectify or remedy an error or omission or benefit from a set of rules or principles of law, such as rectification of register of members. For instance, if somebody has actually bought the shares of a company and the person has been issued a share certificate, but the company has refused to enter his name in the register of members. Such a company, after 1 month of having told such a person, after 1 month of having told the company to enter his name in the register of members, and the company still neglects or refuses to enter his name, such a person can apply to the Federal High Court by way of originating motion for his name to be entered in the register of members, and that is known as rectification of register. That is called rectification of register. And what we are saying now, that the mode of commencing actions now border on something or things like this is called originating motion. So when somebody wants to apply to the Federal High Court for his name to be entered in the register of members, he cannot come by way of originating someone. Rather, he will come by way of originating motion. All right, what type of matters do we commence by way of petition? It is only used where the law expressly requires it, as contained in Rule 4 of the Company Procedural Rules. And you know also that the issue of winding up is inclusive. Issue of winding up must always be by way of what? A petition. Issues of winding up must always be by way of what? A petition. And as regards corporate criminal proceedings, as regards any criminal matter that arises from corporate actions, then the Federal High Court, at the Federal High Court, jurisdiction over any offense under it is vested in any court. So, meaning that it is not only the Federal High Court that is entitled to entertain criminal matters arising from a company's dealing, also the High Court can also entertain that. That is the implication. So this is to say that that Federal High Court does not have exclusivity of jurisdiction in respect to criminal actions of a company, pursuant to Section 251 sub 3 of CAMA. So once the action of a company is criminal, then the exclusive jurisdiction of the Federal High Court is actually eroded. And you can see this in Section 251 sub 3 of Companies and Allied Matters Act. Now let us quickly look at the jurisdiction of Investment and Securities Tribunal. The jurisdiction. What is even Investment and Securities Tribunal? So what jurisdiction do they have? The jurisdiction of the tribunal is contained in Section 284 of Investment and Securities Act, which provide that it shall, to the exclusion of any court of law or body in Nigeria, exercise jurisdiction to hear and determine any of the following matters. And determine any of the following matters. 1. A decision or determination of the Securities and Exchange Commission in operation and application of the Investment and Securities Act, and in particular relating to any dispute. So whenever the Securities and Exchange Commission maybe makes application of law, or whenever the Securities and Exchange Commission does a particular thing and it relates to any investment dispute, then it is the Investment and Securities Tribunal that is going to entertain such a matter to the exclusion of any other court. So meaning that even the Federal High Court is involved. Remember, this has actually been an issue of jurisprudential discourse. The law has already said in the Constitution, by virtue of Section 251, that the Federal High Court has jurisdiction with respect to company matters. And now, Section 284, sub 1 of Investment and Securities Act is now saying now that Investment and Securities Tribunal has exclusive jurisdiction with respect to particular matters that still relate to companies. So which one are we going to take? Some persons have been of the view that the Investment and Securities Tribunal is not coming to collect the powers of the Federal High Court. Instead, it is coming to respect it. Some others have been of the view that the position of Section 284 sub 1 of ISA is in contravention with the provision of Section 251 of the Constitution. And to this extent, it is going to be null and void to the extent of its inconsistency by the authority of Section 1 sub 3 of the Constitution. So now all these things are just jurisprudential discourse for the purpose of our learning. But for law school, just take what I'm giving you now. So later, when we get to the field, we can actually discuss it more exhaustively. So that is the number 1 jurisdiction of the Investment and Securities Tribunal. And the number 2 are matters that are between the capital market operators. those who are the capital market operators, any issue arising between them is actually tried by the Investment and Security Tribunal, that is known as IST. Also, dispute between capital market operator and their client. A dispute between a capital market operator and his client is actually being treated by the IST. Dispute between an investor and securities exchange or capital trade point or clearing settlement agency. So any agency that is into the business of a capital market operation and there is any investor that is having any dispute between them, it is the IST that will actually look into it. Also, dispute between capital market operators and self-regulatory organizations known as SRO. It is also the IST that will entertain such matters. Also, dispute between SEC, that is Securities and Exchange Commission, and SRO, that is known as self-regulatory organizations. It is the IST that will handle it. Dispute between capital market operators and SEC, it is the IST that will handle it. Dispute between an investor and SEC, it is the IST that will handle it. Dispute arising from administration, management, and operation of collective investment scheme. If you remember when we treated the concept of flotation of shares and collective investment scheme, if you listen to our voice note on that, you will see or you will appreciate what the collective investment scheme is. So dispute that arises from any type of the collective investment scheme will be treated or will be heard or handled by the Investment and Securities Tribunal. Now, the tribunal is composed of 10 members. The tribunal is composed, please note this for MCQ. The tribunal is composed of 10 members and the quorum at any sitting is 3 members. I believe by now we know what quorum means. Quorum is the minimum number of persons that must be present before a meeting will commence. So the composition of the members of the tribunal, that is the IST, that is Investment Security Tribunal, has to be 10 members and the quorum must be 3. And the powers of the tribunal include 1, to summon and enforce the attendance of any person and to examine such person on oath. 2, to require the discovery and production of documents. 3, to receive evidence and affidavits. 4, to call for examination of witnesses and documents. 5, to review his decision. 6, to dismiss an application for default or deciding matters ex parte. 7, to set aside any order that is made per incuriam. Per incuriam are orders made in error, that is known as per incuriam. So they can set aside such matters. And it shall also have powers to do anything which in its opinion is incidental to its function. And the tribunal shall be deemed to be a civil court. So the tribunal shall not handle any criminal-oriented matter. So it is only a civil court. And the tribunal has both original and appellate jurisdiction. The tribunal has both original and appellate jurisdiction. The person that is aggrieved by the decision of SEC, that is Securities and Exchange Commission, may institute an action in the tribunal and thereby activating the tribunal's original jurisdiction. So if the Securities and Exchange Commission did anything and you are aggrieved by such an action of Securities and Exchange Commission, you can institute an action against Securities and Exchange Commission. Remember, we have treated their jurisdiction, and you notice that matters arising from the decision of SEC can be treated by IST. So if you are aggrieved, you go to IST. By so doing, now you have activated the original jurisdiction of IST. And such a person can also appeal against a decision from the administrative proceeding of the committee of the SEC. So SEC can actually set up an administrative committee to look into a particular matter. And when that particular committee makes their decision, that their decision is seen as a judgment. So you can now take that decision if you are aggrieved and take it to the IST for IST to look into it and to review it. By so doing, you are activating the appellate jurisdiction of the IST. That is what we mean by it can have both original and appellate jurisdiction. In the case of an appeal must be filed within 30 days of the receipt of the order. So once the administrative proceeding, the administrative committee of the SEC has given its judgment, upon receiving the judgment, you have within 30 days to appeal against it at the IST. And the further appeal will also lie to the Court of Appeal and subsequently to the Supreme Court. This means that appeals from the decision of the IST does not go to the Federal High Court, neither does it go to the state high court. Rather, it goes to the appeal court automatically. But the judgment of the IST would be enforced as if it were the judgment of the Federal High Court. So once Investment and Security Tribunal gives its judgment, that judgment will be enforced as if it was the Federal High Court that gave the judgment. All right, let us look at the evidential issues. Evidential issues with respect to the dealings or with respect to the transactions that has been entered into by a company. Of importance as regards evidence is the document or a contract of a company. So when we are talking about an evidence or evidential issue, it has to do with respect to maybe a document that the company has executed or a contract that the company has entered into. And for this purpose, the proper use of the common seal, the official seal, giving a power to an attorney, and authentication of documents. These are the things we are going to be considering. For instance, the company can give power of attorney. I hope you know. We are now looking at where a company can use its common seal, when a company can use its official seal, when a company gives power of attorney, the effect, and also authentication of a company's document or company's documents. Now, what is a common seal? A company is to have a common seal, the use of which is to be regulated by its article. And when a common seal is required by a company's article and by CAMA, and the common seal is not used in such circumstance, then the document will be invalid. So if it's a type of document that requires a company to use its common seal, and the common seal of such a company is not used on that document, then that document will be invalid. For instance, in a deed of assignment, when a company is either an assignor or an assignee, remember that a company is a juristic person, and the way you typically draft your execution clause of a deed of assignment for a juristic person, I hope you know, you see something like the common seal of probably ABC Limited is hereby affixed and delivered in the presence of, and there has to be a director and a secretary or two directors. So this type of document requires the common seal of a company. So where the common seal of the company is not being affixed or stamped on that particular document, then the document is in itself invalid. That is the effects and the implication of a common seal. Now, what about official seal? Official seal is, for instance, if a company has branches outside Nigeria, if a company has branches, if a company is an international company having businesses all over the world, then that such a company must have what is called an official seal. So the official seal will either embody all the countries that the company is, or they can just use the name international, INTL. The way you see churches, you use something international. Any church that you see that has international means that church has a branch outside Nigeria. So that's what we're talking about now. That any company that has a branch outside Nigeria must have an official seal. And if there is a transborder transaction that is to be engaged into by the transborder transaction, means between this country and this country. So if there is a transborder transaction that is to be engaged into by that company, then it must use its official seal. And when the official seal is not used, then such a document or such a transaction would be in itself invalid. Now, what about the use, or what about the concept of power of attorney? A company may appoint any person in writing under seal, empowering such a person in general or specific matters. Well, what we mean by under seal is that the power that is appointing the person must be by deed. So once a company is appointing somebody or giving somebody power of attorney, such a power of attorney must be by deed. That is what we mean by under seal. And where a deed is signed by a person in accordance with power of attorney so executed, it shall bind the company. Typically, you know that about the law of agency. So when an agent acts and is acting within the purview of the authority that has been given to him, such action is going to bind the principal. That is what we're talking about here. So once I have been given power of attorney as a donee of the power, then it's going to bind my donor, who is what? The company. Also, authentication of documents. Where a document requires authentication by a company, it can be signed by a director, secretary, or any other authorized officer of such a company. So once it is expected for the company to authenticate this particular document. Then a director, a secretary, or any other officer of the company must sign it. And where an officer of a company signs a particular document and that officer now wanted to now come back and now say that this document ought to typically have been stamped by seals, and you went and signed it, the implication is that since you have signed it, it is going to bind the company. This is what happened in the case of SPDC Nigeria Limited versus Alapota. In this case, the company, while reaching an agreement with the community, wanted or intended to deceive them by not using their common seal. Now, however, the managing director of that particular company signed the document. Now, since they wanted to deceive them and the managing director signed the document, the court now held that the use of common seal is not merely because the articles of a company provide so, but if the document requires the use of common seal, is of importance and is also authenticated. So, in this instance now, since you have signed it as the MD of the company and your intent was to deceive these people, the court has held that you are barred from going back from it. So it is going to bind you and it's also going to bind the company. Now, what about service of court processes on a company? A court process shall be served on a company in the manner provided by the rules of the court, and any other document may be served on a company by leaving it at or sealing it by post, or even giving it to the director or secretary. You know that the company, yes, we said that the company is a person under the law, but the company cannot be seen anywhere. You cannot see anybody shake the hand and say that this is the company. So the implication of this now is that, unlike what is obtained about the service of processes in civil litigation, we know very well that service of processes are always by way of personal service. And when personal service cannot be effected, then you go by way of substitute service. Substitute service now can be by post. It can be by giving it to another person that is not that person that is intended to be served. But since a company is not a person, so substitute service is always allowed. So you don't even necessarily need to seek the leave of the court before you can effect a substitute service on a company, that is pasting it on maybe the gate of the company, or even giving it to a director or anybody in the company to give to such a company. Now, how are investment disputes resolved? How are investment disputes resolved? Investment disputes now, for the purpose of this now, is where an international person is involved or where a local is involved. So how are they resolved? For instance, if it is between two local persons, as in two persons from the same country in Nigeria, how is it resolved? And also where it is with respect to an investor from a foreign country and a Nigerian government, how is it resolved? That's what we're about to treat now. So the first step is to exhaust any ADR option. So if maybe in the agreement that is binding between the parties really say that where we have an issue, we are going to go into alternative dispute resolution first, then they have to exhaust the option. Now, if amicable settlement fails in the ADR option, the aggrieved party can then resort to arbitration, where the aggrieved party is a local investor. So when he's a local investor, he shall resort to arbitration. You will know very well that arbitration is also a part of ADR, but it's a higher part of ADR. So the ADR that we're talking about before is let them know whether they can resolve it among themselves. For instance, negotiation, mediation. But when we now go into arbitration now is when we now have an arbitrator, and you know that the award of an arbitrator has a likelihood of bindingness in itself. So now he can now resort to an arbitration under the procedure of the procedure of Arbitration and Conciliation Act, if the person is a local investor. Now, where the aggrieved party is a foreign investor, or the dispute involves a foreign investor, if there is any bilateral or multilateral treaty or agreement to which Nigeria is a party and the country of the foreign investor being also a party, then such a treaty agreement will be resolved. So it will be used. What are we talking about here? For instance, if there is any bilateral arrangement with respect to settlement of investment dispute between Nigeria and maybe South Africa. Now, an investor from South Africa came into Nigeria to invest, and unfortunately, there was a dispute that have arisen between such an investor in South Africa and a Nigerian local investor, or between the South African investor and Nigerian government. Now, if there is any type of sorry. Now, if there is any bilateral arrangement between Nigeria and South Africa with respect to investments, then it is that particular treaty, that particular agreement or arrangement that is going to be resorted to in settling this dispute. Now, but where there is no bilateral arrangement between Nigeria and that other foreign country, then the parties to the dispute can agree on any other national or international machinery for the settlement of their dispute. So where there is no type of agreement between the country of the investor and Nigeria, then that investor and the Nigerian investor, that investor and Nigerian government can agree on any particular country's treaty or machinery of settlement of dispute that they are going to use. But if the parties do not agree on any, then they will now resort to make use of the rules of International Center for Settlement of Investment Dispute, the one we call ICSID, International Center for Investment, for Settlement of Investment Dispute, the one we know as ICSID. And if it involves the Nigerian government, then the Nigerian Investment Promotion Commission is going to serve as a liaison officer between the Nigerian government and that foreign investor. So that is the much we can take in companies proceeding and jurisdictions in this particular topic in corporate law practice. Yes, it's a bit technical. Question most often than not don't come out here, but don't take anything to chance. Still read and still appreciate the voice note, and the Lord will remain our strength in our various areas of endeavor, and also our prayers for those who are praying for first class, for those who are praying for 2-1. I know very little will be praying for 2-2 anyway, and it is good for you not to pray for 2-2, but even if you still finally get 2-2, no problem. You will see at the end of the day, be a professional, because it will get to a stage in this course called law. You will notice that what you just need is leave Nigerian law school, leave. Even if it's past, use it and leave, because the stress of this 1 year is more like it's like it is more than the 5 year stress in the university. But on that note, just make sure that you do your best. Do your best as human, and pray to God too, because most of these things also have some spiritual factors that we also need to cover. So on that, I'm going to be leaving you guys, and I hope to meet you some other time. Do have a great night rest and good night.